Thank you very much for accepting to join me, Dr. Remember Miamingi and Advocate Makoi. Makoi is joining us from Nairobi, and Dr. Miamingi is joining us from Johannesburg, South Africa. So I want to appreciate you to join the conversation today.
Thank you.
So I want to begin by asking you to tell South Sudanese about your opinion of the charges that have been laid against Dr. Riek Machar. So do you think the charges are credible, or from your legal opinion, do you think there's something wrong with the charges? So if you want to begin, Dr. Remember.
Okay. No, thank you. So I want to separate two things. One is whether or not the alleged incident happened or not. That is one issue. And arising from that issue is whether or not proper charges have been leveled properly based on that event. And so the reason why I'm making that distinction is that I am not in any way being insensitive to whatever events that might have happened in Nasir. People lost their lives, families were affected, and those families deserve justice. And those who might be responsible for the event deserve accountability. However, to be able to ensure that there is justice and there is accountability, the rule of law demands that the process as well as the charges should be lawful. Now, where I am seated and looking at what has been stated and watching like any other South Sudanese, we have charges that have been brought by government, which runs from murder to terrorism to treason to issues of even international humanitarian law or crime against humanity. Now, for any of this crime to be so charged, the context is extremely important here. Now, what is the context that we have in South Sudan? We have a context in South Sudan of a permanent ceasefire. We have a context that we do have two commander-in-chiefs until the unified forces. The forces have not been unified. So you have two forces, actually unified, actually not unified. That through coordination, command, and control. The allegation is that White Army, under the directive of one of the commanders, carry out the alleged crimes. Now, if that is true, then though the nature changes dramatically, in my opinion. So that what we're dealing with here, yes, they may be killing. Yes, these are incidences happening within a peace agreement, within the context of a ceasefire, within the context of two armies that have formed a government provided for within a peace agreement. The nature, so the investigation and establishment of violation of a peace, a ceasefire, permanent ceasefire, has to be undertaken by the appropriate body mandated to do that. And it is that body that is in a position to make pronouncement on whether or not a particular act has taken place. Now, because this has not happened, we then have one of the commanders, a constitutional commander, set up an investigative committee, investigate, and therefore is prosecuting on the basis of this crime. I would say that because of the context, the charges that the court are deciding right now are not the appropriate charges that should be, and we'll come to the whether why it's not appropriate again because of the time, the context, and the body that is dealing with it. So my short answer is no.
Okay. So, McCoy, what do you think?
Thank you, Dr. Queer. I'm very appreciative to be on this forum. I do not know whether I fit the bill considering the attendees who have been here before, the likes of Dr. Jok, the likes of Abraham Awolich, and my learned colleague here above us. So, but as he has said before, that when two lawyers are together, you will hear different opinions. You will hear different sides. Yeah, I quite agree with him in terms of contextualizing the charges. I do agree with him. But in order to answer that question, whether the charges are proper or not, I usually pose a question: what would happen if this was not Dr. Riek or IO, SPLM-IO, or SPLA-IO, assuming these crimes were committed by a non-party, a signatory to the party or to the agreement? Does that mean we then use the agreement to address this issue, or do we use the penal court to address the issue? Because the argument is this: the essence of the revitalized agreement is not a suspension per se of the existing natural laws of the country. The penal laws of our country continue to function. What has been done was to harmonize them and to, in essence, if you read the agreement, it says it is to be incorporated. The agreement itself is not the law, but it is forming a part of a whole or a bigger whole. And in this context, I would say some charges are proper and some are not proper. Legally speaking, not contextualizing it, legally speaking. Because if you look at it, the agreement provides that there has to be hybrid court. This is where some of the charges like the war crimes and crimes against genocide and sexual violence are supposed to be addressed by this particular special court. And particularly some offenses have been left to the penal courts of the Republic, 2008. So to the substance of the charges, it is neither here or there, but we shall see. Because I cannot dig into the merits, considering the matter is sub judice. Dr. who is my senior here, will be on my side on this case. I cannot say the charges are improper or not at this particular point, but I can touch on their procedure. And the procedure is this, because we have now two forums that are conflicting, being the revitalized and the penal court. So when we come to that, we will be able to pinpoint which particular charge falls and why. If you have the forum, which is the forum, is it proper for this forum to address this particular offense, to try or entertain a particular offense? Yeah, I think that's my opinion.
So, okay, Dr. Mamba is saying the charges are not, they're not per the law given the circumstance of the situation in South Sudan. You are saying, Makoi, that you seem to be on the fence in terms of the charges. So you have no problem with the case now being in the court. Would you say that since the case is in the court, you have no problem with that? Dr. Remember, do you think the fact that the case in the court is a mistake in the first place? Dr. Makoi, you seem to say it's not a problem that the case is in the court. Am I understanding your positions well?
Yes, that is the correct position. I depart from contextualizing the matter.
Okay.
I go per se by the law itself. We have the penal court and we have the revitalized agreement. If these offenses fall within the revitalized agreement, we can classify whether they are improper or proper based on the revitalized agreement. If particular offenses fall within the penal court, we should be able to say, in this penal code, if you look at the penal code, the sections, does this particular charge, does it fall in this one? Is it an offense in the penal code? For example, war crimes is not an offense under the penal code, but it is an offense under the revitalized agreement.
Okay. So I want to go back before I go to the jurisdiction, or you want to go answer that?
Just because you're raising, yes, I think that it is a legal, but also a political mistake. Political in the sense that why is it that the hybrid court, remember that the hybrid court was to be established, and the mandate of the hybrid court covers crime committed since 15th of December 2013 all the way to the end of the transition period. So it means it covered the sins of the past, present, and the future already within the particular mandate. So if accountability was what was driving this process, we should have already by now the hybrid code operational, and this issue would not have arisen, number one. Number two is that by establishing, and we'll come to the jurisdictional issue according to you very soon, by setting up this particular court on a very shaky legal ground, the government is playing with the lives of people, because if this thing is knocked off on technicalities, and we'll come to that, or on legal grounds, we have an opportunity of a justice wasted because we have a process that is rushed, is not thought through well, and is not in accordance with the prevailing legal provisions. And we'll come to the relationship between the peace agreement and the constitution later on. I will deal with that at that particular point. But right now, I think it is a mistake.
Okay. So now there's something I wanted us to talk about, and Dr. Remember, you touched on it, the issue of the investigation. And when the Minister of Information came out and he said the investigation will be conducted, the investigation will decide the charges, which I think maybe you will tell me is a mistake. But before we you've already made your positions clear in terms of the charges. But before we go to the jurisdictional issue, I want us to also say some things about the investigation itself, which you touched on. When you carry out an investigation, you want the investigation to have some integrity. You want investigation to be impartial. So looking at the investigation, do you know who did it? Who were the people within the investigation? Who are the members of the investigation? How was it composed? And how can we respect the charges that, or the results that they came up with? So what do you know about the investigation itself? Makoi, do you want to go first?
Okay, thank you, Dr. I think I should stress that this particular situation we find ourselves in, the trial of Dr. Riek, is both an opportunity and a tragedy at the same time. It is an opportunity for us to be able to look, to scrutinize, and to be able to reflect on what kind of a legal system do we have in the country. We have seen the clash between the agreements or the laws that we have, the principal laws being the Constitution and the revitalized agreement. That gives us an opportunity to reflect that, because you know the value of a law after it has been put to test. It is both a tragedy at the same time, like Dr. Miamingi said, because now you are having a situation where you are not completely in full control, a situation in which there is a lot of crisis in the country. Politically, one would say it is inconvenient at this time. However, some things happen for a reason. And if it has happened today, we better look at both sides and be able to take the good part of it, and at the same time serve as an advisory to both sides.
So what do you think about the investigation itself, the integrity of the investigation, the fidelity of the investigation?
I think I said like some 7 months ago that I am completely 100% certain that this investigation will be bungled and that the government will mishandle this issue. I have been proven right even when I did not want to be correct. But that is the tragedy we face. There are several issues, and we will come to the law where I will be able to point out why arriving at a particular decision is informed by what has been initiated earlier, an investigation which happened. So the weakness of any step that you take legally is informed by the investigation you have conducted.
Thank you. Dr. Remember?
Yeah. No, so the short answer is no, I don't know. Because what I know is hearsay. I have not seen a document that outlines the terms of reference, the selection process, the vetting process, the mechanism that will guarantee the independence and the transparency of the alleged or purported investigation. I haven't seen it, and it might be there, but the fact that as a citizen, and for that matter, a citizen who is a bit informed, is not aware officially about how this body was put together and who worked on it, what kind of method did they carry, is in itself an indictment of that process. That's number one. Number two is that the fact, the circumstance, again, the context is important. We are told by the government and a media report here that there was a movement of forces from one location to another without the prior information or the prior guarantee of the receiving destination. In other words, if it is about the wrong movement of forces that resulted into clash, Citizen VM is the appropriate investigative mechanism together with RGM that is put in place by the parties to the agreement to investigate this. Now, I don't know, and I have not seen if they were part of the investigation themselves, or this was an investigation that was set up solely by one party to the peace agreement, the party that is alleged to have ordered forces to move inconsistent with the provisions of the agreement, and therefore now in a position to form an investigation, elect the people who will investigate, review the report of those of the committee, and based on that report, then formulate charges. That is in itself really, to say the least, is a joke. And I expected so much from a system that will really want to serve justice, and justice at the highest level possible, because the part my colleague Makoi was making earlier on about equality before the law is that you are able to provide justice in the same quality to every single citizen. You cannot be the judge, the investigator, the prosecutor, and do everything else and just serve us with the end product. So from a procedural perspective, I say this under advisement because I haven't seen the terms of reference, the document, and the that there is no transparency about this, and therefore I am not certain about the independence, the fairness of that particular body and their findings.
Okay. So thank you. And that's one of the things I
Yeah.
was worried
That
about. Okay, go ahead.
the investigation process is a prerogative of the police. The investigative process, if a crime has been committed, it is the police that that investigates. From their investigation, they will be able to ascertain prima facie that in the first instance that this crime, given based on what they have, the evidence they have, they are likely to issue an arrest warrant. They are likely to issue an arrest warrant for the arrest of an individual as suspect. One might look at whatever way you can look at it from wherever you sit. That if you look at it from the point of revitalized agreement, you would invoke the RJMAC, the mechanism that is provided for monitoring. If you look from the point of penal laws, not based on the agreement, then you will look at from the point of police. And my concern has always been that this investigation has squarely been left. The investigating officers happen to be politicians themselves, which then rubbish the entire thing. Because when a figure, when a particular person, we might have our different views about who the past Dr. Riek Machar is, but he has become a very attractive hate figure. To a certain way, he has become a boogeyman. That I think you remember in 2014, where the prosecutor, the key witness, the witness who was for the prosecutor, just came and became what they call hostile witness. And these are likely scenarios that should have been handled properly to avoid a similar embarrassment. Whether it is RJMAC that handles it or it's the police of South Sudan, being through the Ministry of Justice, this thing must be done in accordance with the rule of law. You cannot just say, because it is Riek Machar, we will just bulldoze the whole process because this is Riek Machar, he's always guilty or is always on the wrong side of the law. It cannot be that because everyone is presumed to be innocent under the law.
Okay. So one of the things I and you are a lawyer, so I'm not a lawyer. So one of the things I want to understand is, so this is some sort of a national security issue. So who has the authority to investigate? Is it the regular police? You brought up the issue of the penal code that is part of the transitional constitution, but we also have the agreement. So what the agreement specify is when there is a sort of a conflict, then the agreement takes supremacy. But if there's no any conflict, then the transitional government constitution applies. Now, I don't know who is charged with the task of investigating, and you've mentioned that we don't know there's no transparency. So, who exactly by law is tasked with the duty to investigate issues like this?
I think at the same time, this is a question of responsibility. But there are particular times where compromise is necessary, and this is where this agreement comes in. This agreement is a compromise in itself, and if the government was desirous of handling the matter through the peace agreement, it can still do the same. If it is not desirous of handling it through the peace agreement, it will resort to the laws. This is whereby the government has alternatives. It has alternatives that we can do this, we can follow this path. Of course, all the paths have their consequences. Whatever option you choose, there are consequences that comes with it.
Okay. So,
yes,
Dr. Remember.
Yeah, so your question has two aspects of it that I will want to answer. And of course, building on what Advocate Makoi had said earlier on. One is that the principle here is what is important, that investigation, especially that one, which the executive has an interest in, direct or indirectly, should be carried out by a body that is not directed, controlled, managed, and reports to the same executive. And that is why in some countries you have a director of public prosecution, and in some cases, as indicated, that prerogative lies within the police. Because we don't know anything about how this investigation was put together, and we don't know who was actually, in fact, right? So we are only working on the assumption that given the way the announcements were made and how the process was led, they were at the level of the minister. We did not see the police playing any role. Whether you want to look at it as a process led by the penal code of the country, or you want to look at it as a process led by the peace agreement or not, the principle should be the same. And in this case, that fundamental principle has been violated. So that's one point. But the second point, you're saying, what about in the case where it is alleged to be of a serious nature that it threatens the security of the country? And in fact, it is precisely because of that that you want a thorough, independent investigation. Because if you mismanage it, you can even threaten further the security of that particular country. And so if it was a very serious issue and the executive thought that the police might not handle it, and then they will want an instrument of the parliament to set up a body or an instrument that sets up an independent commission to investigate this with clear public participation. They have mechanism in place to do. But I don't think that any of them, the attempt to be independent and transparent was actually at. I think what happened is, this is an assumption, is that you arrest the guy first and you say, okay, what am I going to do with him? And then you come under serious pressure. You said, okay, let's then do some investigation. But then what do we do? Let's try him. So they work backward rather than putting a mechanism in place that should have guaranteed fair, transparent, independent investigation based on that, charge and prosecute.
Okay, thank you. So that has become very clear. So now I want us to talk about the jurisdictional issue, and that goes back to what both of you touched on, the Article 1182. So in case of a conflict between the agreement and the transitional constitution, then the agreement takes supremacy. So, and that is they've discussed, and then the court came back and they said they have jurisdiction. So I want you to weigh in on this. Does the court have jurisdictional authority to try this case or not? So, Dr. Maba, we want to begin?
Okay, yes. And also, there are a number of legal issues here. And I think this is some of the complex issue, and reasonable lawyers will really disagree. If you're a constitutionalist, your view is that the agreement is between two executive bodies. And that agreement is constitutionalized through incorporation. And incorporation that brings in the normal constitutional amendment processes. And through that process, the agreement is now the Constitution because it has been incorporated into the Constitution. And therefore, there's only one legal order in the country, and that is the Constitution, which has already incorporated the agreement. And as a result, the issue of jurisdiction will not arise except it is inconsistent with the incorporated agreement if you're a constitutionalist at a national level. Now, if you're an international lawyer, there is a problem with that provision. Because if you look very carefully at Article 8.2, it is the most abnormal legal provisions I have seen as a lawyer. Now, it says two things. It says, number one, that this agreement shall be incorporated into the Constitution. But then it says, notwithstanding that incorporation, this agreement, in the event of inconsistency, its provision shall trump. Now, that means there are two Article 2 of the Constitution by virtue of this. Because Article 2 of the Transitional Constitution, which would have been amended through the agreement, provides supremacy of the Constitution, and therefore the agreement is part of it. However, H2 create a parallel process that irrespective of that, notwithstanding that, in spite of that, the agreement remain a legal treaty capable of surpassing the Constitution. Now, that then provides enough context for your question. Now, if this is true, is there a conflict here? The agreement does not provide anything about whether the president or the vice president will be tried or not. The agreement is silent on that. It simply says there shall be Truth and Reconciliation Commission to deal with the issue of truth and reconciliation. But then there shall be hybrid court to cover crime committed, including crimes under South Sudanese law from 15 December to the end of the transitional period. Now, when that happens, when the agreement provides that, The only conflict can only be through interpretation. To say, okay, now the agreement is silent on issues of prosecution. In fact, the agreement does not even provide immunity. The word immunity does not even apply, even for the president in the agreement. So the agreement, the president that derives the immunity from the constitution. The vice president in the constitution before the agreement, the office of the first vice president did not exist in the constitution. So the provision in the constitution that provides no immunity to the vice president does not apply to the first vice president. But if there was an immunity granted to the first vice president in the agreement, we then can say, okay, so the immunity can only be read into the agreement through interpretation, and that will be the issues before the court. I would say that you can read it or not. So now the problem with the court jurisdiction is not the agreement. The problem with the court's jurisdiction is the constitution itself, because the constitution provides, the assumption here is that they are treating Riek Machar as any other vice president, whether first or not. Now, the constitution provides that in the case in which a vice president is charged with crime, the Supreme Court shall exercise jurisdiction over the vice president. So already in the constitution, the jurisdiction is already given to the Supreme Court. Now, the Supreme Court can operate in panels. It can have a panel of 3 to deal with criminal issues, or it can decide to have a full bench to deal. So if indeed the vice president is treated as a vice president, not as suspended and as an ordinary citizen, then the right forum, constitutionally speaking, is the Supreme Court. So the question I'm asking is the court, the special tribunal established to deal with the incidents in Nasir, a panel of the Supreme Court? If it is not a panel of the Supreme Court, then you have the wrong accused before the wrong body. And in law, it means that you do not have personal jurisdiction, subject matter jurisdiction, material jurisdiction, and the decision you issue there will be null and void.
Okay, so I want to ask a question regarding what you said before Makoi weighs in. Now, when we talk about the Constitution and the agreement, so, and you say, do they become one and then the agreement becomes the Constitution? Or were they saying, yes, there's the agreement, there's the Constitution, but then we'll wait for the incorporation of the agreement through an amendment by the Parliament, and then either the agreement becomes part of the Constitution, of the two become one document as the Constitution before the permanent Constitution? So what was the case? Were they becoming one document, or were they still separate until the amendment?
In fact, they have a legal absurdity in Article 8.2 of the agreement. The legal absurdity is political in nature, because 8.2 says that this agreement shall be incorporated into the Constitution. Why? Because the political pact, it is an international treaty, it is all that. It will not have a constitutional force until or unless it is incorporated. And that incorporation then becomes an act of amendment. Now, again, I don't know if my colleague or you have seen the different incorporation instruments. My assumption is that it hasn't incorporated the entire agreement. Otherwise, it will even incorporate all the mechanism in the agreement into the Constitution. So they incorporated the relevant aspect of it. The problem is notwithstanding. The word notwithstanding that incorporation creates 2 distinct legal entities checking each other. So you have a double supremacy. In a situation where there is no conflict, nobody says that they are being treated wrongly, they're supposed to be treated here, the Constitution will flow under Article 2. But the moment one of the parties says, no, you are dealing with me under the wrong treaty, I am supposed to be dealt with here, there's already an interpretational issue, there is conflict. And in that situation, you cannot say, no, the Constitution will, because of notwithstanding the incorporation, the agreement stands as a legal regime. And that, I don't know which lawyer drafted that, but it is a legal absurdity, because you have 2 legal processes that are running parallel when they were supposed to be actually uniform. And now in that case, of course, the principles of the law is this. The treaty or the body of law that came later will take precedent over the body of law that existed before. So, in other words, if in incorporating this agreement, they included notwithstanding into the Constitution, the agreement will stand irrespective of what Article 2 of the Constitution says.
Thank you. Makoi, what do you think?
It's very interesting. It's very interesting, and I think it speaks to our nature as Africans. There's a mentality in us that we despise the knowing and attract the least knowing. In my view, both teams, both parties to the agreement, including the guarantors, did not pay attention to a legal scenario that they were creating. I'm sure the government sent very poor lawyers, very poor drafters, and at the same time, IO came with very poor lawyers. I will say very incompetent lawyers, because there are some things as a lawyer that should never escape your attention. Even a point or a comma should not can change the entire context of something, of a document. If you look at the revitalized agreement, it says it is to be incorporated into something. It means there is a sack, and we are pouring a kilo into the sack to make 50 kilos. That means there is already 49 kilograms in that sack. At the same time, which my learned colleague has empathized, notwithstanding, how can you say I am going in, I'm being swallowed, but notwithstanding, I need to be unswallowed? That notwithstanding, I am powerful than the person who has swallowed me. This is what the agreement says. It says, I am going into this one, I am becoming part of it. And in the event it does not serve my interest, I am a separate entity and I am the supreme being. That is what the agreement is saying. But it speaks to the nature of how we have conducted, those who were helping us to come up with this agreement were looking at it purely as a matter of political convenience. They were trying to find a short-term solution. Let us bring these powermongers together. Let us put them together. They will solve their problems at home. And this is the scenario we are finding ourselves. In my view, when it comes to the issue of whether the agreement is superior or the revitalized is superior, my learned colleague has stressed that you look at hierarchical, which one comes. The one that comes later takes over. That is one point of looking at it. We are interpreting contract. There is what is called constituent power. Is this agreement a result of a constituent power? No. Is the constitution a result of a constituent power? Yes. Although the agreement stipulates there would be a permanent process for coming up with another permanent constitution. In my view, the agreement, the constitution enjoys a wider popularity, a wider legitimacy compared to the agreement. Nevertheless, the agreement is a result of what we call cruel necessity. It is a coup against the transitional constitution itself, but it is a matter of necessity. Why did we come to such an agreement? It is, in my view, a very bad agreement. But for the sake of continuity of a country, for the sake of a country to exist, to minimize the human loss that we were incurring as a country, the economic damage, the infrastructural damage we have suffered as a country, we have to come to such a political agreement. And it is, in fact, an elitist pact. It is an agreement between elites. You can see a constitution is not signed by political parties. A constitution, once it is promulgated, it is assented to. This has been signed. It has not been assented to. And when a bill was enacted, it was to regularize the agreement to become an annex of the constitution. It raises more questions. It raises as whether you look at it from the point of a government that the agreement is inferior to the constitution or the agreement is superior to the constitution. You leave more questions because one, does constitution expire? No. Does this agreement expire? Yes. At the end of the transitional period, will we still have the agreement? Basically, no. Does South Sudan cease to exist? The constitutional process, does it cease to exist? The constitutional government? Absolutely not.
So I want to ask something that related to what you just said, and that was raised recently by the Minister of Justice. And also that's one of the arguments that was made by the judges, to say just because we have an agreement doesn't mean the laws of the countries do not apply. That's one of the arguments they were making. But they know very well that there was an agreement, and that was an agreement it was signed by the government. So there's this assumption that they say that there was a bad agreement, it was imposed on us. It feels like they're saying we don't care about the agreement because it was imposed on us. But they know very well that provision, which both of you have talked about, it is a caveat. It's something that they accepted. So what do you think about what they say that, just because we have an agreement, we cannot just discard the laws of the country, we still have to apply the laws of the country, knowing exactly what they signed with that provision?
Yeah, I mean, you're raising a very fascinating question because it touches, first of all, on the legal nature of the agreement itself. Agreement is between parties, guaranteed by an intergovernmental organization, endorsed by the UN Security Council, and there is possible argument to be made that it's therefore an international treaty. And it is precisely because it is a treaty outside the constitutional order that you want to be able to incorporate it. That is one issue. But there's another second issue that is constitutional itself. The transitional constitution of South Sudan says any treaty, any international treaty that South Sudan is a party to and has ratified, that treaty automatically become an integral part of the constitution of the country. It's another facet. Whether it's an international treaty that has been incorporated through the amendment or not, it will come in through article, the proper article. I think it is 9.3, I don't know, of the constitution that provides for this. So the government is in a fix because first we are in a transitional period, a transitional period that is not provided for in the transitional constitution. The transitional period and the government is constituted by the agreement. The mandate of the government is from the agreement. The power of the president, of the vice president, of everybody else is from the agreement. They are the creator of the agreement. And so to now say just because there is an agreement, that's the point we're even saying that the moment you declare the agreement dead, the government becomes illegitimate because it is created by this agreement, right? So they cannot have their cake and eat it. They sign on to this. They were set out by this body. They call themselves Artigono, and therefore they are bound by the provisions of this agreement as incorporated in the constitution and any other leftover provisions, so that any time there is a conflict in this transitional period, that they are the one who have extended it. We don't even know whether pre-transitional period has ended or not. We don't know. So they extended it this long. They are responsible for it. And that argument, unfortunately, legally speaking, is problematic.
Makoi, what do you think?
Yeah, if I am sure looking at it as a legal philosopher, you get more questions than answers. You get more questions than answers. Because if you look at the ruling of the judiciary, the special court, they are basically saying to hell with the agreement. We don't recognize the agreement. What they are saying is that we were not part of this agreement to begin with. The judiciary of South Sudan considers the revitalized agreement to be a pact, a political pact between the executive together with parliament. This is how they look at it. They look at it from a point that we are not even parties to this agreement as the judiciary. And this is where the ruling came from. The judiciary is basically reiterating that they are a jealous institution for this matter when it comes to this matter. And they are saying we will not hand over what is part of our mandate. The mandate of the judiciary is to try these crimes, the charges, whatever that happens under the penal code, and all even civil matters. And they are saying to hell with the agreement. This is a situation that, in my view, ought to have been addressed early enough because the agreement was signed in 2018. For all these years, Parliament, in its own wisdom or lack of it, has been sitting idly, not doing anything. The executive itself has not moved to rationalize or harmonize any contradiction, any inconsistency in both the agreement and the existing laws. And therefore, we have a legal problem. And it is about to create a constitutional crisis. In fact, under the transitional agreement, transitional constitution, we are supposed to have election in 2015. Up to date, we have not had elections. That means South Sudan is in a state of a constitutional crisis. The operationalizability of this agreement together with the constitution creates more legitimacy issues. And it has been stressed by Dr. Miamingi. The more you kill the agreement, the more you legitimize yourself. The more you hang on to the agreement, the more you discredit the other process. Okay. It is them if you do, them if you don't.
Okay, I want to ask something that relates to the integrity. We can say, for example, let's say the court has no legal authority based on what the agreement says. Let's say that. But then we have a reality on our hands. We have the court, there's a case in court we cannot do anything about. Can we say the judges themselves have the integrity to hear this case impartially, even if we know the legal basis of the court itself is questionable? But the judges themselves have the integrity to listen to the case and then judge impartially. Can we say that, or can we say no, because they've been compromised from the beginning by the process? Or can we give them that credit to say, yes, they can actually judge them?
In my view, we have very reasonable men at the judiciary. In as much as people say the judiciary is on trial also, I still feel that they will do the right thing. And it is my view that the process has started up on the wrong footing. The Chief Justice misdirected himself. The Honorable Chief Justice misdirected himself because what he's trying to tell us is that the Vice President of the Republic, because the Constitution talks about vice presidents. When you bring in the issue, when you invoke the issue of a first vice president, you are talking about revitalized agreement. But let us assume we are dealing with a vice president, okay? The vice president of the Republic cannot be tried by the High Court of South Sudan. He can only be tried by the Supreme Court. And the Chief Justice is a presiding judge in that matter, in the criminal bench of 3. The Chief Justice, together with the Deputy Chief Justice. Looking at it, if you compare the special court as of today with the special court of 2014, you will find that the special court of 2014 was legal, was very sound. This was being because they start us under Section 16 of the Criminal Procedure Act is that special courts can be formed. But these special courts, depending on the trial, whether the offense is under Chapter 5 of the Penal Code, then it has to be tried by a specialized court formed by a high court judge, but not a single judge, a judge together with 2 others, 3. In terms of number, the Chief Justice got it right. But in terms of whether these judges are judges of the High Court, I doubt. The Honorable Justice Alala is a judge of the Supreme Court and he wears his title proudly. You could see that. Whether this one a trial of the first Vice President or is it a trial of Potkang, Gabriel Duop, and the rest. Regardless, whether you put the first Vice President to be number 5 in the charge sheet, it will still the Vice President, the first Vice President. The suspension does not remove his authority. He has just been suspended so that it does not influence investigation or compromise.
So
that was in my view.
Do you think the judges have that integrity to be able to hear the case and rule impartially?
Of course, there is no reason to doubt because this is the only judiciary we have, Dr. Queer. This is the only judiciary we have. And our problem as South Sudanese or as Africans is that we do not trust ourselves, or we do not trust in our ability that a fellow black man can do something innovative, can do something that is less corrupt. The judiciary of South Sudan has been on record. Why should this one be different if the evidence does not suffice?
Okay, thank you. Dr. Remember, what do you think?
Yeah, so let me start on the basis, as Advocate Makoi just said. In law, you cannot build something on nothing. So that's why I'm starting. So on the basis that this entity is a wrong entity, trying the wrong people for a wrong crime, so it doesn't exist in law. And so there are no judges. But let's ask for whether for these people who sit there as individuals, whether they will apply the law. I have a problem because already their first pronouncement on this case is problematic. Judiciary is not party to any agreement. Judiciary does not make law. It is whatever is handed to it by the parliament that it interprets. And so it does not need to be mentioned, a part of that agreement, to be able to interpret it. As long as it's recognized in the Constitution, it interprets it. And for it to say that interpretation in their interpretation, that they actually just gloss over 8.2. I have a great doubt as lawyers. I'm not even as judges. As lawyers, there are already problem in their first pronouncement. Now, the second issue you're asking is, in South Sudan, you can have your integrity. But if you're operating in a system that is established and its outcome is predetermined, it is going to be difficult for you as an individual to operate in that system because the system is supposed to protect you. So we don't know what is the intention of this body, and we don't know what kind of pressure these poor judges are coming under. And we don't know when last they dealt with any sophisticated, even as a lecturer of law, I am struggling with the legal issues that are inherent here. I don't know when last they applied their mind to this. So the context, the political setting, their first pronouncement, the conduct so far of the trial does not instill confidence in me as a citizen, as a lawyer. However, I want to give them the same benefit of doubt that hopefully when they've heard all the evidence and that they gave themselves the opportunity to hear everything, that they will be able to apply the law as faithful servants of the law without fear or favor.
Thank you very much. So this is really fascinating.
Let me come in a little bit to stress a single point here. The process is everything. Criminal justice, procedural fairness is the beginning of justice itself. The purpose of the criminal justice is not to get conviction at all costs. It's not for the prosecutor to get conviction at all costs. It is to make sure the innocent and the culprit are separated. It's to bring the culprit to book and to make sure whoever has been accused falsely is acquitted. If you look at, I do not know, and I told you before that the Chief Justice misdirected himself. I don't know whether he had actually looked at the Constitution properly, whether he has consulted the Criminal Procedure Act, whether he has consulted the Judiciary Act. I do not think so. Because these are two separate entities. You have Port Kang here and Duoplam plus others. These are people who fall under Section 16 of these people under the Judiciary Act. They are supposed to be tried before the High Court because the crimes, the offenses they have been accused with are punishable by death or life imprisonment. That is one. We come then, we weigh, there's a first vice president on this other side. This first vice president is tried before the Supreme Court, and I will get to the rationality of it. Now, you come and then you appoint a special court which has the status of a high court, and it is sitting to try both those without the status of a vice president and a substantive first vice president. In essence, what you are saying that this court is both the Supreme Court and a High Court of South Sudan. In the first instance, it means you have prejudiced the accused persons. Because where does the appeal lie here? Can an appeal of the Supreme Court be can it lie at the Court of Appeal? No, it is hierarchical, it is vertical. It goes up, it does not come down. So now who is this special judge? Who is this wise judge who will then sit and say, I will review the decision of Honorable Alala, who is his senior? Although I do not understand the rationale of our constitution saying the first vice president should be tried together with the speaker, the vice president should be tried by the Supreme Court. Because that means a court of final without appellate jurisdiction means that that person, if he is found guilty, he is guilty. He has no right of appeal. That is the rationality of this one. Natural justice, because you are entitled to an appeal by a higher this one. But it speaks to the nature of our laws, that our laws are highly unsound, they are inharmonious, they are inconsistent. It is a situation we are facing. And it worries me a lot that a person of the status of a Chief Justice, people of the status of justices of the Supreme Court are able to formulate, sit, even when an argument has been put forward that they do not have jurisdiction, they still find, they only look at the agreement and look at the Constitution and say, no, we will pick the agreement, we will pick the Constitution, that gives us jurisdiction. But they have not looked at what will arise, the question that arises of whatever choice they have taken. In my view, whatever the decision that they reach one day, because they have no jurisdiction, whatever they are doing now is null and void.
Okay.
On appeal, it has no substance. Whether they find, they convict, or they whatever they acquit, it has no value. It has no juridical value in law.
Thank you. So we've established that procedural issues are a problem. So the process itself has been compromised from the beginning. So, but both of you have said that you will give them the benefit of the doubt, notwithstanding the process. So we'll see whether they will rule impartially or not. So let's give them that benefit of the doubt. I want to end by asking you, given what you've seen, given the way you know the law, what do you think is the possible verdict? I know that's speculative, but given the charges you've seen, given the process, given what you've witnessed, what do you think is the possible verdict? Dr. Remember?
If this process is based on the law and on the threshold that the evidence has to be proved beyond reasonable doubt, and the judges are only the servants of the law, I only see one outcome, that these accused, unfortunately, whether or not they have committed a crime, they've killed or not is irrelevant. Unfortunately, they will be acquitted and discharged. Not because the crime were committed or not, but because of all the irregularities and all the rushes and all the irrationalities there is. However, if this process is in the service of politics and the outcome is determined politically, whether or not all these processes are irregular, whether there are issues of constitutionality, agreement or not, they will be found guilty. irrespective of the law.
Is it because the whole process was some sort of a political machination from the beginning? Is that why you think it will just be a guilty verdict?
No, so that's what I'm saying, that because I don't know, because I can't read in their mind, I'm saying that if this is a legal process, on technicalities, it will be knocked off.
Oh,
And that would have nothing to do with the substance of the charges themselves, even though the substance of the charges, even if they came to, there will be problems. But I'm saying that if the government has gone ahead to do this irrespective of the law, in spite of the law, they can as well get conviction in spite of the law. And because I don't know, that's why I'm giving this possibility, that if it is according to the law, it will be not guilty. If it is according to politics, it will be guilty, depending on what is in their mind and what influence and power they have in place. I cannot read their mind.
okay. I remember Michael Makoi saying that the investigation will establish whether Dr. Riek is guilty or not. I was like, how can the investigation establish guilt? So that speaks to what you were saying. So
Yeah.
it's a problem. Makoi, what do you think? Guilty or not guilty? And I know we are being speculative, and as Dr. Number
I
said,
will not be able to give a verdict, but I disagree with Dr. Miamingi that politically the verdict will be guilty. I think the loser in this whole entire game is the government. The moment that the Minister of Justice announced the charges and that they are preparing charges against the arrested person, the suspect, there was a serious scrutiny. There was already people were beginning to point out inconsistencies in the position of the government. In the court of public opinion, the government has lost. And this
but
is
do you think
nothing.
they care? Because they don't really care about, because if you look at what they've done so far, do you think they actually care about what the public thinks and what the law is or what the agreement is?
I think
Why would we think they will lose? They know?
I think they already lost in the court of public opinion. That is one. It is, in my opinion, I talk about bungled case, a case that has been bungled. And when we talk about being bungled, it is in the process of arriving at this. It is not that there was no crime committed, because we know now the one who committed this crime, heinous crimes, might be among the accused persons or is actually at large. That we cannot ascertain. No one is got to ascertain that. But the judicial officer sitting as an umpire, sitting as a neutral party, will, based on the strengths of the evidence that have been presented before it. In the court of public opinion, I had already announced my verdict. But in the court of law, I cannot give a verdict. But I have to stress that if you are relying on the WhatsApp messages, on WhatsApp video recordings or phone calls, it is very shocking, because our Evidence Act has not been amended so that you can go to court and say, this is me, I am Dr. Queer, I had signed an agreement with Makoi, who is in Nairobi, and this agreement was signed online. Here is the signature showing Makoi's signature, and that the court will be able to rely on that signature. No, we do not have that. And it speaks to the laziness of our civil servant at the Ministry of Justice and our parliament. We have not, our laws are not up to date with the technology. Section 96 talk about only emails. Unless if you have emails that have been sent by whoever the accused person is, that is what you can legally produce. But any evidence that might be produced in court, because we will question its integrity, we will question how was it preserved, because preservation of evidence is a matter of great importance. And we are in an age of AI. We have even seen even the president or whoever is shown kicking people. How can we be sure that this was not doctored? That is the case. But this is not to say that the evidence that the prosecutor has is doctored. No, I'm merely pointing out the arguments that they will encounter. And this argument and these issues, these particular issues, sets then the ground for appeal, a successful appeal. Whatever this court gives, whatever verdict they give, either with which accused number 1 or accused number 5 or accused number 7, an appeal lies, and the chances of appeal are 90% of succeeding. This is my own how I look at it, legally, not politically.
So you're hopeful that this is going to be a not guilty verdict based on what you've seen. Okay, so thank you very much. I want to ask you about your final words. When I posted this on Facebook, I was saying that this is going to be like sitting in a law class, and that is exactly what happened. I'm learning a lot about the law, about the processes, about the technicalities, and about everything. So this has really been helpful for me, and I'm very sure it would be helpful for other South Sudanese, because these are things people don't actually unpack. We just take them for granted, or we just leave them to the lawyers. And then we look at what other people say about the law. So there's a meta-analysis that we find. But I want to ask you your final word.
Yeah, no. So first, I really want to acknowledge the very important issues that Advocate Makoi has brought up with respect to evidential nature and burden, and I think that is really very important. But also to say, again, politically, that I agree to the extent that it appears that every time Riek Machar is dying politically, the government has a way of giving him a lifeline. You know. Like bring him out. And this trial could be that lifeline that will appeal to sympathy, and public opinion here is extremely important, but also beyond that, it can mobilize. So the longer it goes, actually, politically, it might be very good. But finally, to say that, again, as my colleague said earlier on, these challenges are opening to us as South Sudanese, politicians and lawyers, the challenges that we have in our legal system and how we have governed our country outside the constitution or in spite of the constitution, and the result of that, and how we have actually underfunded and under-resourced our judiciary. That this matter, as significant as it is, could end up actually backfiring just because we have not invested significantly. And I'm hoping that everybody involved in this will put politics aside, put the country first, the peace and the stability of that country first, and deal with this issue with level-mindedness. And that at the end of it, I hope that justice prevails, and that justice will cement our peace and it will take our country forward.
Thank you, Rokomaramba.
Yeah.
Makoi, few words.
Yeah, Dr. Queer, in my view, I welcome this entire process, this entire trial, although now it has not met our expectations, because there were so many things we were expecting to have been done, or should have been done, or ought to have been done. But this, as Dr. Miamingi said, there's a guy who always finds his lifeline is built on difficulties. When he's about to be done, he finds another way of making a comeback. Because I feel what has happened to Dr. Riek Machar now, if he was if he can only speak to those who are mobilizing war and say, we will refuse war by all means, I think Dr. Riek Machar has a higher chance of mobilizing and uniting the country. Because this trial, as we have seen, how he's smiling, his attitude, all of it speaks a lot. And is here because we human, we have the tendency, if you are seen to be the smaller person who is being bullied, there is the Goliath and there is David. If you are the David in the circumstances, the human tendency, it is human nature to side with the weak. And at this particular moment, he's gaining ground. And I hope, and I actually plead with him that wherever his forces are, they should not accept to fight. They should not declare any form of hostility against the government or anybody, so that it does not give credit to what the process that further implicates him. Let him continue, let the process continue like that. But on the other side, we should look at it as a nation that we must be able to deal with our problems and deal with them face on. This trial will provide for lawyers like myself, those who are in the trade of law. We have been able to now look at our laws. Some of the laws we have ignored that we even don't know about, and we see that we have laws that are inconsistent. There are current laws that contradict laws of Southern Sudan. They contradict the constitution itself. And I will mention to you, the constitution says we have there's a particular section, article, that it says there will be a chief justice and a deputy chief justice, plus 9, not less than 9. So you can actually have 100 justices of the Supreme Court. That is the scenario we are having. Then we have the Judiciary Act that says we have the Chief Justice and the Deputy Chief Justice and 5 other justices. So one law is saying we have 7 judges, and the other law is saying we cannot have less than 9, less than 11 judges. We can even have 100. Or we can fill the quorum with justices of the Supreme Court. That is just one issue of inconsistency. And these are all over in all our statutes. In the Grey Book of South Sudan, you'll find every law is contradicting the other one. It means we do not pay attention to how we want to govern our country. Because you cannot, the rule of law will not operate in a vacuum. Constitutionalism does not exist without practice. It is practiced because based on what legal principles are laid down. But right now, my problem is my appeal is for the Ministry of Justice to take its work serious. We cannot have people who are employed there taking public salary, and they are even undoing the republic. As a country now, we have very unsound laws, completely unsound, and it makes work very difficult for lawyers and judges. A very good lawyer will look a very poor lawyer because of the bad laws that are in place. These laws are not bad in terms of how they are passed, but even in the drafting. If laws are improperly drafted, they cease to have the validity of law. So let us look at this trial as unveiling a particular problem. It has lifted a veil on our ignorance that laws, at a particular point, laws will have effect, and these laws will be tested. Will they stand the test of time? That is a good point. On the issue of uniting the country, I think this judgment, whatever the judgment will be, I think it will unite the country. I tend to be optimistic about it because it is simple. Even someone who is not a lawyer is able to give his opinion on this matter. But I wholly thank you, Dr. Quir, for having us and for having me in particular. I did not, like I told you before, I did not think I will be in the same ring with a heavyweight. So thank you.
So thank you. I just want to thank you for being here, because this part of why I started these conversations is to inform the people, because it's not about me. It's not about even the guests who speak here. It's about the people. And that's why I bring people who will inform the public. When I said on Facebook that this is going to be like sitting in a law class, I was serious. And this is exactly what happens. And many people will see why it's crucial to listen from experts, to sort of unpack things we take at face value.